What you are about to hear is not a podcast. This is a global conversation recorded live in real time with real people.
Journalists,
business leaders,
academics, politicians. I think the term's a deep state. Oh dear.
investors,
Experts, diplomats.
citizens.
Coming together from around the world to share their views and ask our guests the questions. If you would like to join this conversation or hear our incredible library of past conversations, please visit our website, pm101.club, and join the fastest growing conscious community on the free internet. Thanks for being here.
Enjoy the
Enjoy the show. Hey everyone, welcome back to Politics and Media 101, the place where we all hear live and direct from people in the news, in their own voices, in their own words, in long form, and where anyone who wants to can join to ask them a question, share their thoughts, or just listen. I'm Jeff Browning, and I'm grateful to you for being here. Today we're excited to release part of a live conversation, interview, and audience Q&A we had with Dahlia Lithwick, a contributing editor at Newsweek and senior editor at Slate, who's an expert on the U.S. Supreme Court. The three branches of the U.S. government are supposed to keep each other in check, and the Supreme Court especially is supposed to play a non-political role in deciding the biggest, toughest questions of how to interpret federal law. Although Supreme Court justices are appointed by presidents, they're not supposed to be beholden to those presidents. They're supposed to use independent judgment on the cases in front of them. In recent years, the court has narrowed protections for voting rights, but during the 2020 election, the court did not directly insert itself to disqualify votes in key states or to throw out legitimate election results in order to keep Donald Trump in power. However, this begs the question of whether the court will involve itself in elections in the future or in deciding who becomes president. If it does, that could have serious impacts on our democracy and on critical parts of the American experiment that have gotten us this far, but that people don't often see and therefore might sometimes take for granted. The good news is, in our system, problems can be fixed. Democracy can be reformed to last. But first, we have to have a shared, clear-eyed view of what the threats are and how to respond. Dahlia is an unparalleled expert on the business currently before the court, how it impacts us, and how it's likely to play out. We had great audience questions. It was a fascinating conversation, and we hope you enjoy it as much as we did. As always, if you like or dislike what you hear, if you want to find out how to join us live almost every day of the week, maybe ask one of our upcoming guests a question, or hear past episodes, please visit our website, pm101.club or pm101.live. They both work and will get you to the same place where you can find all that and more. Without any further ado, let's roll the tape.
So before we get into it, this is obviously going to be a big term for the Supreme Court, but maybe outside of that, as we're approaching the holiday season, do you have anything you're particularly looking forward to this week? Could be, personal life, professional life. What do you got going on?
Well, this week is going to be, it's not personal, but as we learned, the personal is the political. And I'm still absorbing the Texas abortion decision from Friday. And I think just as signaling goes, it suggests we're going to really, really just get a string of pretty rough losses at the court this term. And so I guess this doesn't sound positive, but I feel as though for folks who thought maybe it wasn't going to be all bad, or it wasn't going to be bad for a couple of years, or that this was manageable. There's some tiny, it's ridiculous to say it, but there's some tiny filament of gratitude that at least now everybody's masks off and the gaslighting is over and we can sort of fight it on its own terms. And I know that's not about my personal holiday plans, but that is, there's some relief in the candor and the honesty of the conversation after Friday.
Yeah, that's why we're having you on. I'll do the introduction shortly. But from my perspective, I was a legislative assistant on Capitol Hill, worked for a governor, and the Supreme Court still was rather confusing to me because the mainstream media only really dives in, you excluded and a few others excluded, when it's that big type of Obergefell, ACA type of case. And then even then, we don't really understand what's going on at the granular level. What does it mean in the larger historical context of things? So I think having you kind of walk us through it is going to be absolutely awesome. So I wanted to thank you for.
It's my pleasure. Justin, I used to tell people, like, I've covered the court for 20 years, and I used to tell people it was like covering a jack in the box that, like, kind of wound up, all year. And then for last 2 weeks in June, everybody paid attention as the big decisions came down. And, we in the press do that too, right? Like, we also, I think, fudge over not just like some of the little cases that make a big difference, but like the big years long trends and developments that you can't just do for 2 weeks in June when the Obergefell kinds of cases come down. And so I think it's not just a failure, to process it correctly as consumers of the media. I think it's just a massive civics failure in understanding that the court is kind of operative all year long and doing stuff all year long, and that to only pay attention to those 3-4 big ticket cases in June was at all of our peril. And so I guess I'm just saying, to the extent that folks feel that they just don't kind of have the scope of what the court does, I think that's partly on us in the press for covering it as though it's a great big 2-week surprise party for the last 2 weeks in June.
But how has the court changed since you first started reporting on it? Obviously, the composition has changed, but how has this change in composition tangibly affected its maybe the interpersonal dynamics of the judges, the procedures that they use, and then obviously, lastly, some of the decisions that we're seeing?
So as table setting questions go, Justin, that's like the whole enchilada. Like, that's a really broad question. And I think probably the short answer is it's changed, I would say, in the last 3 or 4 years, probably, with the 3 Donald Trump appointees. And I don't think this is a partisan point. I think both the Federalist Society folks who worked very, very hard to get those 3 justices seated at the court, and progressives who have watched it unspool, would both say that the court has changed structurally, because we always had, in my 2 decades covering the court, we always had kind of a 4-4 court with someone at the center that was called a swing vote. That swing vote was, for the first part of my career, Sandra Day O'Connor, a Ronald Reagan appointee, notably a conservative, but who was very, very much, I think, willing to modulate what she thought on a lot of really key issues of the day, whether it was affirmative action, whether it was religious displays on public lands, certainly whether it was abortion. She was kind of, I guess the word is, in play. When she retired, that median position went to Anthony Kennedy, and this is where places like, you mentioned Obergefell, Whole Women's Health, the big abortion case from 2016. Again, Kennedy was a reliable conservative, but in play on some of those issues. I think what really has changed sort of fundamentally is that we now have a 6-3 conservative supermajority. To the extent somebody's in play, and I know we're going to talk about this, it's John Roberts, the Chief Justice. But in play for him means that he votes occasionally with the 3 liberal justices in dissent. He is not the median justice. The median justice is Brett Kavanaugh. And so I think on the big picture, for the first time in my career, we have a reliably conservative Supreme Court, and that the median justice is very, very much further to the right than the 2 median justices that came before. So that's the sort of big descriptor. I think on the, how is it changed in terms of interpersonal dynamics and how the court presents itself? I think my short answer, and we can, pull at this a little in the conversation, is that this past October, so when the first Monday in October, when the term started, was the first time I ever saw throughout the mainstream press, the curtain raisers were, yes, they sort of mentioned there's a huge gun case on the docket. There's, big environmental cases on the docket. There's certainly abortion cases on the docket. But the big frame was the legitimacy of the court. The big frame was Gallup polling shows that in the history of Gallup polling, the court has the lowest approval numbers we've ever seen. What does that signal? You may recall right before the term began, we had a raft of speeches, one by Amy Coney Barrett, who flew out to Kentucky to the Mitch McConnell Center to give a speech about how the court are not partisan hacks. Sam Alito flew out to Notre Dame to give a speech excoriating the press for drawing attention to the shadow docket, which I know we're going to talk about. Clarence Thomas was, feted as a sort of hero of the right. So and Justice Breyer was out stumping, promoting his book, saying that the court is nonpartisan. So I think this is the first term I have ever seen the story shift from this is the term, these are the justices, these are the cases, to this is a court that is on the brink of massive public illegitimacy. These are the moves that the justices are making to try to address that, discuss. And that kind of vaulting of the court into a profoundly political and institutional conversation, that's the first time I've ever seen that happen.
No, that is very true. And I kind of want to shift into that question on legitimacy in a 2019, so a little bit further back, amicus brief. Senator Sheldon Whitehouse, who will have as a guest on this show on Tuesday, wrote, quote, "The Supreme Court is not well, and the people know it." End quote. As you mentioned, the public's perception of the Supreme Court is at a all-time low and also critical to its legitimacy. So I want to take this from a little bit different of a perspective, Dahlia. What aspects of this sort of critique on the Supreme Court's legitimacy are overblown and maybe just part of partisan hyperbole?
It's a great question. And I think, part of the problem, and we should talk about the commission, the Biden Blue Panel Commission on Court Reform just handed in this massive hundreds of pages report on Thursday. And we should talk about that because that kind of goes directly to this question of legitimacy. And the reason I say it's a hard question is there's really no good way to measure it. And I would start where you and I both started, which is polling, right? Like polling is a horrible, horrible instrument to determine public legitimacy. And even the questions that are asked, in the Marquette poll, in the Quinnipiac poll, in the Gallup poll you mentioned, they're so easy to fudge the questions to get responses that suggest that the court is legitimate or illegitimate. And so I think in some sense, the whole issue is overblown insofar as do we really know what the public thinks about the court and what do these instruments tell us? That said, I think two markers of, what is real are worth focusing on. One is, and I don't think we need to sort of draw this out, but I think that at least two of the Donald Trump nominees, Neil Gorsuch and Amy Coney Barrett, were seated as part of this juggernaut that Mitch McConnell was performing, when he had control of the Senate, both in terms of blockading Merrick Garland for almost a year, keeping the court seat of Antonin Scalia empty for almost a year so that Trump could fill that seat. So that was one piece of it. And then at the other end, the bookend, after Ruth Bader Ginsburg died, with just weeks to go, and in fact, when the voting had already begun in the 2020 election, sort of mashing Amy Coney Barrett into that seat in violation of his own stated principle about, we don't seat justices in election years. So I think those two actions, in a sense, turned the court into a political football. It became clear that you can say balls and strikes all you want, but, to the winner goes the spoils. Whoever's in control of the Senate is in control of the court. And I think for a lot of people, that's the marker for when, now we really have to think about this legitimacy problem. And then I think the other one is a much shorter time span, which is the rise of the shadow docket and the conversation we had this summer, but had actually been going on for a long time, about the ways in which the court was taking more and more and more cases on its emergency docket. It was resolving them without briefing, without arguments. Often it was resolving them, in two unsigned paragraphs in orders that were inscrutable and actually could not be applied to future cases. And I think what happened this summer is that kind of with a boom, 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 after a whole bunch of COVID cases had been resolved on the shadow docket, we saw the Remain in Mexico policy, we saw the Biden eviction moratorium, and then SB 8 in Texas all got resolved on that emergency docket, sometimes, at midnight. Again, we don't even know who voted in some of those cases. And I think that was a wake-up call that something funny was happening, that for a court whose entire legitimacy, Justin, rests on showing its work, was not showing its work, was making decisions without explaining, without fully considering, without arguments and briefs. And so the only coda to that, I will say, and this was Justice Alito's complaint about the shadow docket, is that there has always been an emergency docket, and the court, particularly in death penalty cases, has always resolved things, quickly and without extensive briefing on emergency cases. But the idea that massive, massive cases like all of California's COVID lockdown orders, or the Biden eviction moratorium, or the reproductive freedom of 10% of people of childbearing age in the United States and Texas, that could get decided on the emergency docket, I think sent off massive, massive alarms for people who maybe had some sense that, it seems weird that it's Mitch McConnell's court and we all only visit there. Now it seemed as though the court itself was instrumental in doing something that was worrying.
So thank you very much for that, Dahlia. You just hit on two specific critiques of legitimacy. The court essentially lacking transparency, not showing their work, as you said, and then also the partisan nature of control of the court going through the Senate, as underlined, highlighted, maybe exposed by Mitch McConnell's norm-breaking approach to either nominating or not nominating Supreme Court justices. You also just hit on the presidential commission, Biden's presidential commission on the Supreme Court, which released its report just this past week. I was wondering what you made of this report, and do you think that it could lead to any substantive reform, or is this more partisan messaging that has become known throughout our?
So the knock on the report initially was Biden was asked when it was, at your part one, right, when it was clear that Mitch McConnell was going to seat Amy Coney Barrett. This is in the wake of a very, very contentious Brett Kavanaugh hearing and contentious Neil Gorsuch hearing, that he was going to do it a third time. And then candidate Biden was asked, what's your plan on court packing? And his response was, I'm going to task a whole bunch of smart people, if I'm elected, to study court packing. What the commission was, and I think this was much to the frustration of a lot of very sort of progressive court watchers, was that this looked like kicking the can down the road, right? Like if you're, the minute you're constituting a blue panel commission, it feels as though you don't want to solve the problem or really think about the problem. And one of the things that was really interesting when the commission voted to release the report last week was the extent to which the commissioners said, and I want to really pause and say, holy hell, these commissioners are amazing. And they range from, incredibly important thinkers and scholars on the right to important civil rights lawyers like Sherilyn Ifill from the NAACP Legal Defense Fund and Larry Tribe. So these are not hacks, but what they are certainly not, I think, were people who came in with the dog in the fight for court packing. So these are, very scholarly, thoughtful people. They were very clear when they released the report that they had not been tasked even with making recommendations. What they were tasked with was laying out the field, the scope of, these are the kinds of things that folks are talking about. Court expansion was one of them. Term limits was another, jurisdiction stripping, a whole host of ethics and transparency reforms that actually a lot of them dovetail with Senator Sheldon Whitehouse's requests that the court do better on ethics rules and on financial disclosure. But the sum of the thing is that they produced what I guess is just a really singularly scholarly book report saying, here's all the stuff. Here's what all the scholars think about this stuff. We are not in agreement about court packing. We are not in agreement about jurisdiction stripping. We are not in agreement about term limits. We are in more agreement about some of these ethics and transparency reforms. But by and large, and I think this goes back to your very first question about legitimacy, all of these things, to a greater or lesser extent, really undermine the legitimacy of the court. And that was, by the way, a much more acute problem. We saw an earlier draft of the report that really, really started from the posture that if you do anything at all, you're undermining the court's legitimacy, therefore do nothing. I think that changed between the draft report and the report we saw this week. But I think this is part of this, I think, really existential problem, which is if you are an institutionalist, and most of the people on this commission were, you need a court that is legitimate. It doesn't work to have a court that decides the 2022 or 2024 election and 2/3 of the country says, yes, I don't care. And so they're really invested. Even, I think Commissioner Sherilyn Ifill said, look, I'm a civil rights attorney, but we need a functioning court because what is plan B if the American people don't abide by the court rulings? And so then I think because they're institutionalists who are first and foremost invested in protecting institutional legitimacy, the report certainly doesn't suggest, as I said, there's no formal recommendations. It doesn't look like a document that Joe Biden picks up and says, oh my God, this is so hot. It's on fire. I got to do something. It looks like a very brilliant piece of scholarship and not a lot more.
Yeah, well, thank you very much for that comprehensive answer. Unfortunately, that's what I was fearing a little bit. So I wanted to transition over to the term ahead of us, Dahlia. We have quite a blockbuster term ahead of us, and I thought we could go through a few cases that have potential to reshape the legal landscape, starting with religious freedom cases, which have always been an important part of American jurisprudence, but seem to be getting more attention from the court as of late. As the court's composition has evolved, which we've already touched on a little bit, have we noticed a major change in how the court approaches religious cases? As we've gone from Kennedy and Ginsburg to Kavanaugh and Barrett, what's the difference for the establishment and free exercise clause?
So that I feel like is the most essential question that folks haven't really wrapped their heads around. And by folks, I mean, I include myself. I think that we have seen a fundamental shift in the doctrine around religious liberty. And in some sense, some of the really essential things happened on the shadow docket in those COVID cases that don't have comprehensive analysis. So we're not quite sure. We know the doctrine seems to have changed even in the last year, but we don't quite know the scope of that. And that in itself is a worry. But I think just in the most general sense, and we just this past week, we saw oral argument in a case that had to do with taxpayer funding of the school system in Maine and the use of taxpayer dollars to send students, because of the vagaries of Maine and how spread out rural students are, there was a program that allowed students to be sent on the taxpayer dime to private schools. The line was, you cannot be at a school that is a religious school that actually teaches faith, that where faith is part of the curriculum. That was challenged by parents who wanted to send their kids to such schools. It's very, very clear, I think, from oral argument that that's going to be fine. The reason it's interesting is that's part of a line of cases that we have seen unrolling in the last few years. It started, folks may remember, in Trinity Lutheran, which looked like it was a case about the rubber stuff that you put in playgrounds so that kids don't skin their knees. In that case, Chief Justice John Roberts said that a state program that gave those kinds of benefits to secular schools but not religious schools was discriminating. That really became a line of cases that brings us to Carson this past week, where the zeitgeist at the court now is that you are discriminating if you're withholding money from religious schools, even religious schools that are expressly teaching religious dogma or that do not let LGBTQ folks send their kids there or let those people teach. And so I think that we've kind of come full circle in terms of where, religious liberty is. And I guess what I would just say is part of the reason we missed it is because it happened in the COVID cases. And it happened in the COVID cases when the court was, in 2 or 3 lines, setting aside first New York, California, COVID restrictions, and saying that religious liberty was inflected in such a way that the court had to jump in. In some of these cases, the state lockdown orders had actually been rescinded already, but that there was this exigent need to allow people to gather in prayer during COVID. And what the formal technical term for that the religious liberty scholars use is most favored nation status, that religious liberty now is treated as though the most special right. And we've seen that really happen inside of a year at the court, that now religious liberty is getting this most favored nation status. And what is interesting is that because in part it happened on the shadow docket, because in part I don't think folks have fully tracked it, we are now kind of living in a world, and I would commend to folks our last Amicus podcast last week with Catherine Franke at Columbia Law School, where she really lays out what it means to have rights from the Bill of Rights tiered so that religious liberty rights are at the top. And that, I think, is a massive ground shift that has happened under our noses in the last couple of years, and I think a lot of us failed to clock it.
So, Dahlia, I wanted to take the religious aspect from a little bit different perspective. Are the justices concerned about consistency in how the First Amendment protections apply to different religions? Justice Scalia seems to approach religious exemptions differently for Native American plaintiffs in a 1990 case than he did for Christian plaintiffs in the Hobby Lobby case. The Dunn v. Ray ruling from 2019 was also sharply criticized for preventing a death row inmate from access to a Muslim imam. The court may have the chance to correct this with Ramirez v. Collier, which also concerns religious rights during executions. Religious freedom cases are becoming more and more salient. How is the court thinking about its rulings and how they apply to non-Christians?
It's such a good question. And I want to maybe my first cut at this answer is that I feel as though, the Supreme Court and religion is without a doubt the third rail of the constitutional and legal and judicial conversation we are having right now. In other words, we more freely talk about the justices' love lives, their sex lives, their political lives than we talk about religion. And that is for some good reasons. And I always am careful to say, the Constitution explicitly has protection. There are no religious tests for public office holders. It is not appropriate to scrutinize any public office holder's religion and how that changes the way they think. But I think that to fail to see that we have at this moment 6 Catholics or former Catholics on the court that is deciding not just religious liberty, as you just said, but deciding issues that have threads in the religious doctrine is to kind of blinker ourselves to a problem. And famously, Professor Jeff Stone, after an earlier abortion case came down several years ago, wrote a piece saying, how can we not talk about the fact that this is at the time 5-4 Catholic majority that is deciding against abortion. How can we not talk about it? And he was pilloried from the right and the left. Justice Scalia at the time said, "I will no longer visit Chicago Law School where Professor Stone teaches because I'm so affronted by the implication." You may recall when Dianne Feinstein tried to question Amy Coney Barrett, not for her Supreme Court confirmation hearings, but her confirmation hearings to the Seventh Circuit, when she tried to probe the connection between Barrett's own, not just her religious faith, but her writings, her express writings about how her own religion affected how she thought about the Constitution, pilloried again from the left and the right. So it seems as though the big elephant in the room is, how do we talk about an institution that decides questions of religion and religious liberty, and also questions that have to do with religion, if we can't talk about the interplay between the justice's own views on religion? And I quite honestly am confounded by that. I don't know how to pick my way through this conversation, and I really welcome folks' thoughts on this, because it seemed to me we didn't do a great job during the Barrett confirmation hearing in figuring out how to ask about some of that. So that's my sort of big precatory, welcome to my nervous breakdown comment. But I think I would just say that you have really highlighted the problem, which is the court shows immense solicitude for some religious plaintiffs and not for others. And whether it was Hobby Lobby and the court bending over backward to protect the conscience objections of the Conestoga Cabinet Company, the Green family, the incredible centering of their religious need to not provide contraception to their workers because they believed it was an abortifacient, even if it wasn't an abortifacient. And contrast that, as you say, to the line of cases where you have death row prisoners who want a person of their own faith in the chamber with them, and the court summarily dismissing it. So it's a huge problem. And I think I would just say this. I don't know how we talk about it in the press. We're not doing a great job. But B, it becomes worse when people like Justice Alito give speeches where he really talks about the war on religious people, the war on traditional Christian values. In other words, the court isn't silent on this. The court is quite voluble, or at least members of the court are quite voluble about it. And quite honestly, we don't know what to do with that either. When we get speeches like that, when we get just the reality that is that before the first Monday in October, there's something called a Red Mass on the Sunday before, which is a Catholic Mass that the justices attend year after year. Justice Ginsburg stopped attending because the one year there was this inveighing against abortion and she found it uncomfortable. But I just think the intersection of faith and the court's work is so complex, and we keep pretending it away. And that worries me almost more than anything.
Yeah, we had McKay Coppins on, an Atlantic writer, and he got pilloried for focusing on Mitt Romney's religion during his last presidential run. And that was a big existential question that we discussed. And he came basically out on your side saying we need to discuss this stuff, especially if it's influencing the decision makers that guide our government. I don't know if we came to a way how to do it, because it sounds like right now with social media, Dahlia, people can pick and choose and just attack based on the portrayal of the religious question, which makes it very difficult to have any type of nuanced discourse that just doesn't run amok. So if you figure out how to do that, we'd all love to know in the future.
Yeah, and I think I would just say this. Look, there is a robust conversation happening in this country about denying Joe Biden communion, right? I mean, this is not just Mitt Romney. It's not just members of the court. I think that it goes to how closely braided together faith and, governance are. in a country that is at least theoretically not supposed to be taking that into account. And I think, when I think back to a year ago to the Barrett hearings, and how almost impossible, even as I said, this was Justice then Judge Barrett introducing into the discussion. She had written about what do you do if you're a judge of faith and you're supposed to apply the death penalty and your faith does. In other words, she wanted to have that conversation in the public forum, and the unwillingness, I think, to engage on it precisely because, I always say to people in these conversations, let's remember, like Justice Brandeis almost didn't get confirmed because the public conversation around his Jewish faith was so toxic that he almost wasn't elevated to the court. And so this is very, very thorny. And you're exactly right that it is a conversation that is so nuanced and so complex that the worst way we could do it is in Twitter. But I think that we're at a moment now, and we really, really saw this, by the way. I know we're going to get to the Dobbs argument at the Supreme Court. But when the court is talking about fetal personhood, when the court is talking about, those are theological ideas. Those are not constitutional ideas. And when you are getting the court itself inserting itself with language of, as long as there are safe harbor laws and mothers can give up their babies for adoption, so we don't have to worry about the viability standard. Those are inflected with theological valences, and to not be able to think or talk about them is really, really, I think it's just short-sighted and ultimately really, really dangerous.
Yeah, we're going to get into abortion right now. I'm going to have one or two more questions, then we'll go to the audience. The first, the way we do things, folks, is wait for your name to be called on. Be respectful, especially if you disagree, and be short so that we can get through as many people as possible. The first person asking questions will be Steve Crone, a former two-time Supreme Court clerk. But I do want to get into abortion, and the Texas case has received a ton of media attention, as well as the Mississippi case. And the Mississippi case gets to the heart of Roe v. Wade. People across America were glued to the recent oral arguments in that case, which is, as we've noted, kind of rare. What were your major takeaways from listening to those arguments? And were there any comments by the justices that you felt signaled a particular outcome?
I think I was very much of the view, and I have been, I think probably since Justice Kavanaugh replaced Justice Kennedy at the median of the court, that I think I started writing in 2018, Roe is going to be over. I was of the view, I think mistakenly, that would happen slowly and invisibly. That, I've famously said over and over again, so many of us had, you're never going to see the line Roe v. Wade is overturned, because the court doesn't need to do that. And it would garner, particularly in, the summer before the 2022 election, nothing but ill will. I was surprised at Dobbs. I think everybody would agree that it seems as though the court is actually more apt to write the sentence Roe v. Wade is overturned than any of us believed. And to the extent that there was a middle path, and that path was going to be, we move the viability line. It's currently at 24 weeks, right? You can't have a ban, an outright ban pre-viability. The court would move it, as Mississippi did, from 24 weeks to 15 weeks. And, the next case would come in a year, and that would move it to 6 weeks and then 2 weeks. And that was going to be how it went, without ever seeing the sentence Roe v. Wade is no longer good law. The only person in the Dobbs argument who had any interest in that project was the Chief Justice, who was really fixated on, maybe I can justify 15 weeks, and here's why. I counted 0 other justices on the right flank of the court who were interested in that project. I counted, I think, 5 other justices who really, really either wanted to talk about how, Roe is nowhere in the Constitution. Clarence Thomas kept saying, I don't understand. Where is this? It's what in the privacy rights, what, penumbras, what's going on? Or in, the very, very long discursion that Brett Kavanaugh had about precedent and stare decisis. And, Brett Kavanaugh and several justices overtly compared Roe v. Wade to Plessy versus Ferguson, right? That was the case that enshrined separate but equal. And basically made the case that, look, bad cases should be overturned. And this is a bad case. And precedent should not bind us if the original holding was wrong. And I saw an immense amount of enthusiasm for that project, which means that for those of us who thought that the court was going to do abortion in baby steps, again, in the context of this is a term in which the court has a massive gun case that it heard last month on the docket. It has possibly, we don't know, an affirmative action case, a bunch of environmental cases. It has SB 8, which it just decided, that's the Texas ban. So it wasn't like the court isn't going to be in the crosshairs those last 2 weeks in June. So why go big if you can go small and wait for another day? And what I saw in the Dobbs argument was a real almost enthusiasm for going big. And whether going big expressly means overturning Roe, I mean, we can have that debate, but whether it means functionally making abortion impossible, I think that there's 5 votes for that. And I think that the one slight miscalculation I made was I thought that the court would strike down Texas's efforts in the SB 8 bill because this is the so-called vigilante bill, the one that offers anybody in the country a bounty, a $10,000 bounty, if they successfully sue either an abortion provider or somebody who, quote, aids and abets an abortion provider. And that came down on Friday, and I had thought the court would simply strike that down under some theory of, the supremacy clause, or, states don't get to overturn or nullify constitutional law. And the court did not do that. The court left a very narrow opening for abortion providers to sue in Texas, but they didn't overtly side against Texas. And so I thought the court was going to try to give a win on the one hand to providers in Texas and a loss in Mississippi. And I think that even that signals to me that the court is not pumping the brakes, and that those of us who thought, and this goes back to your legitimacy question, those of us who thought that legitimacy was kind of front of mind at the court and was going to dictate what happened this term, we really just may have overplayed that. I think the court actually doesn't much care.
We're going to go to audience questions, and we will start with Steve Crone, then we'll go to Marshall, and then Eve. Steve, because you were a 2-time Supreme Court clerk, if you have 2 questions, that is fine. So go.
Following up on the abortion case, I agree with your estimation. I mean, there are obviously at least 2, and it does look like 4 or 5 votes to overturn Roe. But I want to ask one follow-up question about a line of questioning by the chief. Do you think that there's any hope that he can get even one other justice, because that's all it would take, one from the right, I should say, in order to not have a majority to overturn Roe? Do you think there's any chance he can get one justice to subscribe to the following theory, which he did ask about in argument? We need to draw a new line. Viability doesn't make sense. We should draw a line. The Constitution does have something to say about abortion, but we just need to draw a line in a place that gives a pregnant person a reasonable opportunity to ascertain that they're pregnant and make a decision about whether to terminate their pregnancy. Maybe that's 9 weeks, maybe that's 12 weeks, maybe that's 15 weeks, but we're not going to overturn Roe. We're simply going to move the line on a new principle. Do you think there's any chance? Again, that wouldn't become the law of the land, obviously, if there were only 2 votes for it, but it would at least mean there was no majority opinion in terms of doctrine.
I thought so, Steve, and folks should go back and look at the end of last term, at the end of the 2020 term in June, there were a whole bunch of pieces that said, hey, this is not a 6-3 court. This is a 3-3-3 court. And while it's true that Clarence Thomas and Sam Alito and usually Neil Gorsuch are going to be sort of far to the right, we have this center block at the court that is comprised of Chief Justice Roberts, Amy Coney Barrett, and Brett Kavanaugh. As I said when we opened, Brett Kavanaugh is now the median justice after last term. So I think there was a lot of hope in, Justice Kavanaugh had sort of signaled that he was maybe willing to go slow in an earlier case. So I think there was some reason to believe that either Brett Kavanaugh or Amy Coney Barrett, for all the reasons that you just said, Steve, which is not because they are not fundamentally 100% for the project of reversing Roe, but for reasons of legitimacy, for the reason that they both could be on the court for 30 years. There's no reason to do it in 2022. They can do it in 2025. So I think there was some reason to believe that they would try to find some compromise position that fundamentally, gutted the holding of Roe and Casey, but didn't in fact write those words. The only reason I saw no enthusiasm from either of them for joining the chief, and I agree descriptively that was what the chief wanted to do, is that Kavanaugh really, really was, I think, almost obsessively focused on overturning precedent and why it's fine. And if the court makes a mistake, it has to course correct. And I didn't see anything in Justice Barrett signaling that she was really interested. I mean, she did ask about the viability line, but I really think her view of it, and to the extent that, the Chief Justice was saying, and I agree, what he was saying is, look, 15 weeks is plenty of time for a pregnant person to find out they're pregnant and terminate. So we don't need those extra weeks. And what I saw Justice Barrett doing with those safe haven questions about, hey, it's now so much easier to give your baby up for adoption, right? You just have the baby and plunk it at the firehouse. And so there's no burden there's no parenting burden left post Casey. I just didn't think that she was at all on board for the chief kind of nudging the line in the other direction. She was nudging the line, in my view, toward there is absolutely no discernible harm to the mother for carrying to term. And so I just didn't get a 3-3-3 vibe from that argument at all. And I think that's where it would have come from, one of those two.
Thank you for that. Steve, do you have another question?
I have a quick second question. Although I agree with what you said earlier that I don't think it's likely to happen, I'm curious, just on principle, whether you like the idea in the bill introduced by Ro Khanna and others to simply appoint a new justice every 2 years and have term limits. What do you think of that substantively, regardless of the prognostications about it?
Yeah, I have to say I am at this point completely in the camp of yes and. In other words, I am for court expansion, I am for term limits, I am for jurisdiction stripping. There's very little that I'm not open to. I have spent my whole life being wildly opposed to court expansion, aka court packing, for all the reasons that you can read about in the report. I do think it's destabilizing. I think it's mutually assured destruction. And I think that for all the talk of term limiting the justices, it's very, very clear, and you'll see this in the report, that cannot happen absent a constitutional amendment. And so we're just not going to get that. We can't even pass a law, much less amend the Constitution. So I think that a lot of the kind of conversation about, what should we do and can we do this? And, I say do all of it, and do all of it free from the fear that it's going to be done to us, because my view is it's already, in that sense, been done. So I think my real concern about a lot of these plans, which, by the way, are getting very little traction, very little attention, the various bills that are out there seem to be generating very little enthusiasm. And my sense is, and we should have talked about this at the beginning, and I didn't, but I'll just say this and then we should take more questions. But the part of the court's legitimacy we haven't talked about at all are the decisions that go to vote suppression, that go to gerrymandering, that go to Shelby County eviscerating the Voting Rights Act, Brnovich from this last term eviscerating what's left of the Voting Rights Act. So we haven't talked at all today, but I think it's the single most essential piece of this about the court being engaged in a democracy breaking project, a project to make it harder and harder for legislative and majoritarian change in the elected branches. And I can't say enough that for people who say, and Steve, this is sort of adjacent to your question, but I think it's important. Okay, well, if the court overturns Roe, you just pass WIPA, right? The Women's Health Protection Act. You just codify Roe. The problem is it's becoming harder and harder and harder to do those legislative fixes. And that's in no small part back to the court. That's because malapportioned districts, gerrymandering, a massively malapportioned Senate, the Electoral College structurally entrenches minority rule. And then when the court either blesses that or furthers that project, the court becomes, I think, really, really complicit in a project of diminishing majority rule. And so I just want to be really crisp about this point, because people say, look, the court is supposed to be a counter-majoritarian check, right? It's not supposed to reflect the will of the majority, and that's why we got Brown v. Board. And that is descriptively accurate. But when the court is getting itself involved in a project to set aside election results in Wisconsin, to set aside ballots in Pennsylvania, stuff that was starting to bubble up in the 2020 election and couldn't quite command 5 votes, then the court is not in a project of counter-majoritarian check. It isn't a project of subverting majority rule in the other branches. And I just say that partly totally unresponsive to Steve's question, but I think that's the only way we can think our way through court reform. And a lot of the commissioners, by the way, if you look, Judge Nancy Gertner and Larry Tribe, Kim Roosevelt, there's been a bunch of the commissioners who, in the day after the Blue Ribbon report came out, said, we have to expand the court. We just have to expand the court because the court is breaking democracy. And I think that, unfortunately, is the way we have to look at all of this.
Again, that's rather scary, Dahlia. So thank you for putting a crisp, fine point on that. We will go to Marshall for one question, then Eve, and then Greg Sattel. Marshall.
Thanks so much for having me. There's a lot there to chew on, Miss Lithwick. I don't know if it's Miss or Mrs., but I've definitely listened to your podcast. I really enjoy it. I work in the Republican Party in Texas. So there's a lot there, but I think probably the thing I kind of want to ask about is what happens if we do go to that mutually assured destruction piece. There's a political part of this, but I'd like to hear us work through what that would mean for the court as a whole. Because I think it was on one of the podcasts that you hosted that I listened to somebody make a very similar argument about mutually assured destruction. And so it was a conversation that never, I felt like, had an adequate end to it. I was just curious if you could explore that just a little bit.
Marshall, it is. I do think it is the question. And I think that, a lot of folks will tell you that, this is the answer that, for instance, Judge Gertner gives when she says pack the court. What she says is we've already seen court packing, right? Because Mitch McConnell held the court to 8 justices for virtually all of 2016. And so the idea that 9 is sacrosanct, and you put aside the fact that 9 is nowhere in the Constitution and lots of presidents have packed the court. And, we think about the court as having 9 magic numbers, and that's wrong. But I think your sort of normative point is completely correct, which is, and this has been the fight since Bork, and this has been the fight since the filibuster, right? Is that if one side disarms or one side arms, then it is guaranteed to create blowback. And my answer is, it is really going to be terrible if someday there is a Supreme Court of 276 members. But also, I think it's really worth noting, and again, this is in the Biden Commission report, no other country only has 9 justices. Most other countries have significant, bigger Supreme Courts, and none of them have lifetime tenure. So this is a weird historic aberration that we are living in this juristocracy where 9 people, where you and I, everything that we have is going to be decided by Brett Kavanaugh. And I think that in some sense, the helpful thing is to disaggregate the conversation from, did it start with Bork or did it start with Garland? I don't think that's useful, and I think you're flicking at that. I think the better thing to do when we talk about court reform is not who started it and what did they do, but what does an optimal Supreme Court look like? And in no other country in the world is there a Supreme Court of 9 people who sit for life, who decide everything for everybody. And so I think taking some cues from other courts, you can have courts of 20 members and the judges sit in panels. They don't have to sit en banc. These are all vestiges of American constitutional history that, absent the current moment, are not serving. They're not serving the right or the left. And so my view is, and I think, by the way, this was the view of the panel of the commission, let's separate whatever is going wrong with this court and its legitimacy and think about structurally what court reform could look like. And I think if we are being fair across the ideological board, a 9-member juristocracy that serves for life is not good. And so could we come to a better arrangement if we put our heads together? And I think that's part of what the commission was trying to do. I feel like that's not responsive, but I think that we are living in a world where everybody is upping the stakes. You probably also saw that Gavin Newsom is now going to talk about an SB 8 style bill in California around gun ownership. I'm not sure that greenlighting vigilantism across the country is a super idea, but I also think that this is the problem with mutually assured destruction. And I think it doesn't feel good to be a part of saying, that we should just disarm and let the court belong to Mitch McConnell.
We will go to Greg Sattel, and then we will go to John Gunnarsson. Greg, over.
Dahlia, thank you so much for being here. Could you talk a little bit about how you expect the relationships on the court to evolve, particularly with respect to Chief Justice Roberts? Is he going to be more to borrow a phrase, is he more on the inside pissing out or the outside pissing in or somewhere?
I love that question, and I actually love that turn of phrase. I'm never, ever going to be able to think about John Roberts without thinking of urine for the rest of my life. So I just filed on Friday a piece suggesting that the real lesson for me of the SB 8 decision, where Roberts sides, as he did on the shadow docket in September, he sides with the 3 liberals, not because he likes Roe v. Wade, it's plain he hates Roe v. Wade, but because he's worried about, all the stuff we've talked about, institutional legitimacy and Supreme Court supremacy, and no lower court and no state is going to tell the court what to do. And again, he's alone. He's with the 3 liberals. And it's very, very clear to me that the notion that he had some kind of massive sway over the other 5 conservative justices was probably also overplayed. So, the simple mathematical way of thinking of it is the minute Amy Coney Barrett was seated and John Roberts was no longer the center of the court, there was a lot of, it's okay because either you have this 3-3-3 theory where Roberts and Kavanaugh and Barrett are going to sort of modulate the extremes, or a theory that goes, because John Roberts, as Chief Justice, he only has 1 vote, right? But what he does have is assignment power. He can assign the majority opinion. And it's in his interest. That's how he controls, right? This is what Chief Justice Warren Burger did so deftly as chief. By controlling who writes, you can really control the scope of an opinion. And I think there was a sense in which we thought that he had still a very, very big thumbprint over the majority. And it feels to me, at least in the SB8, both on the shadow docket and again on Friday, that has just slid away, that the court is just not interested in acceding to him as kind of lighting the way towards institutional legitimacy, or going slowly, or doing one thing but saying you're doing another. All of those John Roberts tricks, from the day he told us he was calling balls and strikes, seem to just have no force with the bulk of the majority. And so, there's really interesting little relationships that you can point at. It's clear that in the last year, Elena Kagan and Steve Breyer have really carefully aligned themselves with the chief, and they're being very strategic. In a lot of ways, it leaves Sonia Sotomayor to dissent alone. She did write for Breyer and Kagan on Friday, but she's often just alone, sort of speaking for the left, because we're seeing kind of tactical moves on the part of Breyer, Kagan, sometimes Kavanaugh, sometimes Barrett. But I think in a deep, deep, deep way, I'm getting more and more comfortable saying, and I say it with great regret, that I don't think John Roberts is the boss of his court anymore.
Thank you for that question answer. We will so it looks like Eve is back, so we'll go to Eve and then John, and that'll be it. I'll go to Dahlia for her last thoughts. So Eve.
Thank you, Justin. I was having trouble unmuting. And thank goodness for you, Dahlia. This is such a great, important conversation, and love to hear from you how to remedy the following. On your podcast, the episode with Julie Reichelman, who argued for reproductive rights and liberty in Dobbs versus Jackson's Women's Health, she discussed how she brought into her argument data on women's progress in society, educationally, financially, work-wise, due to the women's own reproductive choices and access. And the Supreme Court the judges kind of batted this line of argument away. And so how do we really bring into the discussion women's true voices, the realistic circumstances and needs and hard choices that weren't really considered in the court's discussion?
So first I want to say and send out love to Eve, who does heroic work for women every day. And I want to, answer that question by saying that I really went back and counted, even in the SB8 decision from Friday, how many times in Justice Gorsuch's opinion he says women or pregnant. It's not there. It's not there. It's only actually in Sonia Sotomayor's dissent that you hear about real women on the ground, pregnant people in Texas having to wait to get a procedure. There's a 4-week wait to get into a clinic in Oklahoma, if you're lucky, right? And just the horrifying 101 days, she said, now it's 103 days that people in Texas have been without access to a constitutionally protected right. And what Julie Rickleman said, and it's so important, Eve, is that we did not have this data in Casey in 1992. The court made the claim that absent abortion, women could not reach economic equality and parity, and didn't have the data to support it. And so this is a brief that was filed, an amicus brief, on behalf of a whole bunch of Nobel Prize winning economists, now amassing that data. And as Eve said, when Julie Rickleman, representing the Center for Reproductive Rights, tried to talk about it, John Roberts said, put that data aside. He just didn't even want to hear it, much less assess it. And I think that it's kind of a piece with what I was attributing to Catherine Franke, which is we can't have first and second tier constitutional rights. I assure you that when Bruin, the gun case, comes down, I suspect massively expanding gun rights in America, the word gun is not going to be absent from the opinion. The word gun is going to be everywhere. So we can't continue to live in a world where reproductive freedoms, privacy, dignity, all of that is like a 5th tier right. And the court doesn't even have to say the word women, and doesn't even have to say the word pregnant, and doesn't have to look at the data, as Eve says, and is just making stuff up. And then we have first tier rights like gun ownerships and property rights, and those are treated seriously. So, what's the answer to that? I mean, you know the answer, and it is like to be visible and to do all the work to show the court that we're watching and we're listening and we don't agree to being invisible. And, there were many, 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 many women on the plaza when Dobbs was argued. We all have to do better. We really, really have to insist that we're here and that an opinion that decides reproductive freedom without mentioning women is not an opinion that can be treated seriously.
Thank you very much for that question, Eve. I want to go to John Gunnison real quick for a last question.
Thanks very much, Dahlia. You were talking a lot about how the court is approaching democracy. And I wanted to ask about this through the prism of this 2016 ruling, which was the decision to vacate the criminal conviction of Governor Bob McDonnell of Virginia. And in the process of doing so, severely weakened the anti-bribery laws that we have, setting a standard for a kind of explicit quid pro quo for bribery that almost never exists in the real world. And I think what was most striking about this decision was that it was a 9-0 decision. It was all of the Democratic appointed justices and all of the Republican appointed justice unanimously deciding to weaken the anti-bribery laws in this way. I was wondering for a while, could this be because of the milieu in which all Supreme Court justices live, where the only people that might be affected by bribery laws are the people who they socialize with, justices and judges as well as public office holders? Is there really any hope for anti-corruption laws with the current Supreme Court? Do you see the Supreme Court blocking and watering down any kind of issue of public corruption in light not only of Citizens United, but also this kind of unanimous ruling on the McDonnell case?
It's such a good question, and it warrants a really elaborate answer. And I think my very truncated answer is that, in part, you're right. I think that we are in a world now, and we really saw it in Citizens United as well, where there seems to be a view at the court that unless you walk in with Scrooge McDuck money bags with dollar signs on them and plunk them, on a desk and ask for a quid pro quo, everything else is okay. And I think I'm not sure it's necessarily attributable to the fact that the justices pal around with elected officials, although I think Justice Breyer said some of that when the McDonnell case was being argued. But I think it's just a complete absence in their lives of understanding how money in politics works. And this is where I just say, as soon as Justin gets Senator Sheldon Whitehouse on this podcast, you all should listen to every word he says, because he's been writing and thinking about this for years. Until we lost Sandra Day O'Connor at the court, there was always somebody who had served in elected office sitting on the court. There was always somebody who understood how politics is done, and that is gone now. We don't have a single person who's ever served. And I think it goes to a little bit Eve's question, too, about the weird, rarefied world in which the justices operate, where they just don't know how politics works. And one of the things that the commission really did agree on was that a lot of the money in politics, dark money stuff that not only affects, really corrupts electoral politics generally, but is in fact, I think Senator Whitehouse would say, is corrupting the court itself, is allowing these 5-4 pro-business decisions, anti-union decisions, overwhelmingly are a result of dark money in court politics. And so I think it all has to be reformed, probably from the outside in. And that I think that the commission was actually pretty clear that that could happen and should happen. The court's not going to like it. But I think, in other words, I guess I'm saying there's two tiers of the problem. One is the court's pronouncements about elected officials. And I think you're quite right. They have no idea what the standard is that they have set. But more profoundly, the ways in which big money, dark money, these multi-million-dollar campaigns to seat justices are starting to allow the justices to sort of give back to dark money communities in ways that are corrupting, not just elections, but First Amendment rights and speech rights and other rights. So I completely agree. I think this is something we've ignored too long at our peril.
Thank you for that question, Mr. Gunnison. Dahlia, I just wanted to thank you so much for taking an hour of your time on a Sunday to walk us through all things Supreme Court. Before you go, I just want to tell the audience, go read her articles in Slate and all over the place, especially the past ones. It'll help you understand what is going on. But again, Dahlia, thank you so much for walking us through all of that. We'd love to have you back once these decisions start to come out, and maybe you can help us make sense of it.
It's a pleasure to be here. And I just want to say to folks who are feeling helpless and disempowered, I really think that the ticket to fixing all this, and it sucks because there's a filibuster, but is democracy reform in all of its iterations. I think that, as long as there is an electoral college and a malapportioned Senate and gerrymandering and all that stuff, it is easy to feel really powerless. That's the stuff that can be fixed, but folks really need to absolutely lean into that right now more than ever. Thank you for having me, Justin.
That's all we have for you today. Again, huge thanks to Dahlia for coming out, to our audience for their fantastic questions, and to you for being here. If you like or dislike what you hear, if you want to find out how to join us live almost every day of the week, or maybe ask one of our upcoming guests a question, please visit our website, pm101.club or pm101.live, where you can find all that and more. This has been Politics and Media 101, produced in partnership with Clubhouse. I'm Jeff Browning. On behalf of Justin Higgins, our co-founder, and our team, thank you very much for being here. We hope to see you and hear from you soon.